Welcome to Talking Business, your straight talking guide to dealing with corporate matters. Whether you are a private or public company, an owner managed business or an entrepreneur, a director, company secretary, or in house counsel, this is the podcast for you. My name is Sophie Brooks, and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Hi everyone. We've a few things to cover this month after our Easter break, so including 2 cases on unfair prejudice petitions. Don't worry, I'll explain what those are, and a heads up on some new proposed legislation to crack down on the misuse of non-disclosure agreements, NDAs. But first up, let's look at a case where the Court of Appeal held that a partner who resigned from a partnership was entitled to be paid their share of the value of the partnership assets, despite the fact that the partnership agreement didn't actually contain any provision to that effect. So, this case involved a dispute between the partners in a family partnership that operated a 600-acre Yorkshire farm. And the partnership had originally been set up by sort of the family's grandparents, but then by the time of the dispute, the 4 partners were 3 siblings, so 2 brothers, their sister, and then their father. So the partners had all entered into a partnership agreement under which each of those 4 partners was entitled to an equal 1/4 share in the partnership profits. Whilst the agreement set out various circumstances in which a partner would cease to be a partner, it was silent on a partner's ability to just unilaterally resign from the partnership, to say, I don't want to be a partner anymore. Interestingly, there's also no such right under the Partnership Act of 1890. So in this case, the sister who lived and worked in London had no day-to-day involvement in the partnership. Perhaps mindful of the fact that as a partner, she was liable for the debts and obligations of the partnership, which in fact had made a loss in both 2008 and 2009. So the sister wrote to the other partners in June 2010 to confirm my resignation from the partnership with immediate effect. The other partners, under the mistaken belief that she was in fact entitled to resign, all accepted her resignation, but they continued in partnership together, operating the farm, and took over the assets and liabilities of that partnership. But nothing was said or agreed between the partners about the financial terms on which the sister was to leave the family partnership. Now, after the sister had resigned, in other proceedings, the partnership was found to have the benefit of a yearly tenancy of the farmland, which was protected under the Agricultural Holdings Act. And that asset, that protected tenancy, had a substantial value, despite the fact that it hadn't actually ever previously been recorded in the partnership accounts due to the fact that the partners weren't aware it existed. So the sister claimed she was entitled to a payment reflecting her interest, her 1/4 share of the partnership assets. Essentially, that was 1/4 of the value of this agricultural tenancy at the time of her resignation. So at first instance, when the case first came before the courts, the judge agreed with the sister. But the continuing partners appealed the judge's decision, arguing that there was no express agreement that the sister was entitled to such a payment. There was no basis for implying an agreement to that effect, and there was no other statutory or legal basis for any such entitlement. They argued that by retiring from the partnership, the sister had effectively just given up her interest in the partnership assets. So, what happened on the appeal? Well, the Court of Appeal dismissed the continuing partner's appeal. So the court said, look, the assets of a partnership are owned collectively by the partners. So each partner has a proprietary interest in the partnership property. And when determining what happens to that proprietary interest when a partner retires, well, the first port of call should obviously be what the partners have agreed in the partnership agreement. But then the court went on to think about, well, if that agreement is silent, then what's the position, like it was here? So the court rejected the continuing partner submission that a partner who resigns without any agreement as to whether or not a payment should be made is to be taken as agreeing to surrender or assign their interest in the continuing uh, to the continuing partners without any payment. The court said, hang on a minute, there being no agreement as to what, if anything, should be paid is very different from there being an agreement that nothing should be paid. So here, there was no agreement about what should be paid, and the continuing partners were saying that amounted to an agreement that nothing should be paid. And the court said, no, no, those are two very different things. So, since the sister's resignation, the court said the continuing partners had continued to use her interest in the partnership assets without accounting to her for it. And the court said that they should now be required to do so based on the actual value of the relevant assets at the relevant time rather than on their book values, because those book values would be based on a historic cost, or actually, in the case of the agricultural tenancy, it would be nil because that wasn't known at the time of her resignation and therefore it hadn't been included in the accounts. So the court said it was inappropriate to look at book values in those circumstances. So it was an interesting case. It's a good reminder, obviously, of the importance of partners agreeing all relevant terms in a written partnership agreement. Now, I know I would say that because I'm a lawyer, but the problem is that if you don't do that and you don't have an express agreement about what should happen, then disputes and litigation can result in the court stepping in to decide what the appropriate arrangements are. And obviously, that might not be what the partners actually want. All partnerships are different, so you can't really have a one size fits all approach, and the exact requirements are going to vary. So, for example, professional partnerships, so accountancy practices, some solicitors firms, architects, those kind of things. They'll generally provide that a retiring partner is not entitled to receive any payment for their share of the partnership assets, and those assets will simply transfer automatically to the continuing partners. But in a family farming partnership, like we had in this case, and which are very common, very careful thought needs to be given to how, on a partner's retirement or resignation, the interests of those partners who wish to continue farming can be reconciled with those who wish to realise their property and their interest in the partnership assets. So that was a partnership case. I mentioned that there's going to be some new legislation to crack down on the misuse of non disclosure agreements or NDAs. So, this was an announcement that the government has made saying it's going to introduce legislation to stop NDAs being used to prevent victims from reporting a crime or from disclosing it to certain groups. So, the proposal is one of six recommendations actually that have been included in the government's response to its 2019 consultation on the misuse of confidentiality clauses. And that consultation was launched following high profile cases. You might remember, in particular, the one involving Zelda Perkins and Harvey Weinstein. And it was launched in order to address concerns that victims of sexual harassment felt unable to report crimes or seek appropriate medical or legal help because of the very extensive gagging clauses that were included in settlement agreements that those people were required to sign. So, the intention is that the new legislation will clarify that NDAs cannot be legally enforced if they prevent victims from reporting a crime. And it will also ensure that information related to criminal conduct, whatever that means, can be discussed with certain groups without fear of legal action. So, those groups are the police or other bodies which investigate or prosecute crime, qualified and regulated lawyers, and then other support services such as counsellors, advocacy services, or medical professionals, which operate under clear confidentiality principles. So, like I say, the government announcement doesn't actually give any indication of what's meant by information related to criminal conduct, which is what victims can share with those groups. Um, so it's not clear whether that actually requires a crime to have been committed or merely that the victim suspects that something may be a crime. Also, it's not limited just to crimes involving sexual harassment. Other forms of hate crime, so for example, relating to race or disability or religion, they will also be caught by this new legislation. So, one thing that I just wanted to stress, kind of in the context, particularly of this podcast, where we're very much looking at corporate law and transactions involving companies, the government has said that not all confidentiality clauses will be affected by the legislation. So, it's very common in, for example, a corporate transaction where one buyer is looking at acquiring a company, for there to be a form of NDA, non-disclosure agreement, so that the sellers can share information about the target company with prospective buyers. So buyers can decide whether or not they want to make an offer, and if so, at what kind of level. But those kind of agreements will not be affected by this legislation. The government recognises that NDAs can legitimately be used to protect commercially sensitive information, financial agreements, other obligations. And that's unrelated to the type of disclosures that the government's seeking to protect here. And those kind of commercial NDAs will retain their legal effect. So, in terms of timing, the government has said that legislation will be introduced as soon as parliamentary time allows. But I have to say, given that it's 5 years since the original consultation on this was launched, it remains to be seen whether the legislation will be passed before the general election, and then whether it still continues to be taken up once we've had that general election. Okay, so now let's move on and look at two unfair prejudice cases that I mentioned. So, in the first one, the Court of Appeal has overturned 40 years of received wisdom by holding that unfair prejudice petitions are subject to statutory limitation periods, with the precise length of the relevant limitation period depending on the type of remedy that's being claimed. So, first up, let's have a quick explainer on unfair prejudice claims and limitation periods. So, an unfair prejudice claim is a statutory remedy that's available to shareholders of a company under the Companies Act. And it's the main procedural route for a minority shareholder to petition the court when they believe that the company's affairs are being conducted in a manner that is unfairly prejudicial to their interests as a minority shareholder in the company. The courts are given a very wide discretion to make any order that they think fit to give relief if an unfair prejudice petition is successful. The most common order that gets made is one being for one party to buy out another's shares in the relevant company where the unfair prejudice has been alleged. So that's unfair prejudice claims. In terms of limitation periods, so the Limitation Act sets out limitation periods for different types of claim. And when the Act applies, an action has to be started within the relevant limitation period, or it's time barred. And in which case, if it's time barred, then the defendant, the person against who you're trying to bring your claim, will have a complete defence to that claim if you don't bring it within the relevant time period. So, like I say, courts have long assumed that the Limitation Act does not apply to unfair prejudice petitions, and therefore the usual limitation periods for bringing claims don't apply. So that's meant that, in theory, an unfair prejudice petition could be brought many years after the alleged unfair conduct that the shareholder is complaining about actually occurred. But in practice, the courts have often used that wide discretion that I was talking about to refuse relief where the delay in bringing a petition would make it unfair or inappropriate to grant relief. So, in this most recent case, the Court of Appeal was asked to decide whether, as a matter of principle, any limitation period applies to an unfair prejudice petition brought under the Companies Act. And in what was a unanimous decision, the court held that yes, the Limitation Act does apply to statutory unfair prejudice claims. The court examined that historic assumption that limitation periods weren't relevant and said it couldn't find any justification for that assumption. So it said the Limitation Act imposes limitation periods in respect of different types of action, and an action included any proceedings in a court of law. So an unfair prejudice petition, which initiates proceedings in court, could fall within the scope of the Limitation Act. And when thinking about the applicable limitation period, the court said that a shareholder's right to petition for relief for unfair prejudice was derived from statute only, so the Companies Act, and not any common law or equity. And so as a result, it would fall under the section of the Limitation Act which imposes a 12-year limitation period on claims deriving from statute and, in fact, from a deed. But the court also acknowledged that that 12-year limitation period could be displaced by a shorter period set out in another provision of the Act. So, where the remedy sought by the petitioner involved monetary compensation, as actually was the position in the particular case here, the claim would fall under a different section which imposed a shorter 6-year limitation period for monetary claims. So in this particular case, that meant that on the facts, the petitioner's claim was time barred. But if the relief sought had been non-monetary, so for example, something like a claim for specific performance, then the relevant limitation period would have remained at 12 years. So it was a bit of a surprising decision, but it's helpful that the Court of Appeal has now definitively ruled that unfair prejudice petitions are subject to limitation periods. It means, therefore, that shareholders and directors should consider very carefully any timing constraints when either asserting or defending unfair prejudice claims. There are still some sort of unanswered questions, I think, including, for example, whether a court could still summarily dismiss a petition on the grounds of delay, effectively exercising that wide discretion that it has under the Companies Act, even where the petition has been brought within the applicable statutory limitation period. So you're bringing a claim for unfair prejudice, you're not asking for a monetary remedy, therefore you have 12 years to complain. But actually, if it takes you to the 11th year to complain about a piece of conduct, might the court still be prepared to dismiss that claim if it felt there had been undue delay, using, like I say, its wide discretion that it has under the Companies Act? We will have to see. Helpfully, the court did confirm that a buyout order, like I said, that's the most typical remedy that you get in an unfair prejudice claim, where the petitioner effectively asks the court to order the other shareholders to buy the petitioner's shares. The Court of Appeal said that remedy, a buyout order, is not a monetary claim. Because it's analogous to an order for specific performance, and therefore, in the context, if you are asking for a buyout order, that longer 12-year limitation period would apply. Okay, and then finally, there's another case that was involving an unfair prejudice petition, and in this one, the High Court had to consider the meaning of an obligation in a shareholders' agreement to seek an exit by a particular date, and whether that obligation had been breached, and if so, what were the consequences of that breach. So in this case, the relevant company was a holding company of a group that provided creative services to brands in the fashion, beauty, and luxury brands sector. And in 2016, following a refinancing, the company and its shareholders entered into an agreement setting out various governance arrangements. The agreement included an obligation on the company and its shareholders to work together in good faith towards an exit no later than the 31st of December 2019. And it defined an exit as a sale of all the company's issued share capital. The parties also agreed that they would give good faith consideration to any opportunities for an exit before that date, before the 31st of December 2019, and if no exit had been achieved by that date, then an investment bank would be engaged to cause an exit. In fact, as you may have guessed, no exit occurred before the 31st of December. And in fact, at the time of the court case in October 2023, an exit had still not taken place. So the case involved a claim by an investor who was a minority shareholder in the company. And interestingly, rather than claiming for breach of the obligation in the shareholders' agreement, the remedy for which would have been damages, the investor brought an unfair prejudice claim, arguing that the failure to perform the obligation in the shareholders' agreement constituted conduct which was unfairly prejudicial to the investor, and that that failure was caused by the company's chair, who was also a shareholder indirectly via his investment company. So by bringing that unfair prejudice claim, it meant that the investor was able to seek a buyout of its shares as a remedy, potentially effectively giving the investor that exit that it desired and that had been provided for but missed in the shareholders' agreement. So, when the court had to look at this and analyse what was going on, it had to consider various different points in relation to that exit obligation that I've described in the shareholders' agreement. So, firstly, the court thought about whether the obligation should be read as including a carve out so that the directors were not obliged to comply with it if doing so would be in breach of their fiduciary duties. So, if the directors felt actually this is not in the best interest of the company, did they still have to pursue an exit? So, the company argued that by pursuing a deal today, so by that specified deadline, rather than waiting for a better deal tomorrow, the directors would potentially be in breach of their fiduciary duties. Now, whilst the judge agreed that the directors were generally obliged to seek the best price for the shareholders, they said that the question of whether to elect for jam today over jam tomorrow was a commercial one, and the directors could not be in breach of their fiduciary duties by seeking an offer at a particular time, so by complying or trying to comply with that 31st December deadline. Next up, the court thought about whether the obligation to seek an exit by 31st December 2019 was satisfied by having engaged in preparations for an exit before that date. Now, the judge noted that it was true that the company was pursuing an exit, but actually, the obligation in the shareholders' agreement was not to pursue an exit at a time the directors considered reasonable. It was to do so by a fixed date. So, a decision by the directors to defer a sale beyond the end of 2019 was not permitted by the terms of the clause, even if the directors believed that actually that was commercially reasonable. That wasn't what the contractual obligation obliged them to do. Next, the court considered whether a sale to a new company into which some of the existing shareholders rolled over part of their investment, becoming shareholders in the acquisition vehicle, was an exit for the purposes of the shareholders' agreement. Here, the judge said that where a purchase was made by a vehicle with a capital structure that was entirely different from the target, it was misleading to speak of shareholders just rolling over. What they were actually doing was selling an investment with one particular set of characteristics and acquiring another investment with a very different set of characteristics. As the judge noted, it would be relatively standard practice for a private equity house to look for some of the existing shareholders to remain invested in a company it acquired. But the judge said that would still constitute an exit under the agreement. And then finally, the court considered whether, if an exit was not achieved by the end of 2019, the shareholders' agreement imposed any other timetable on the process of then causing an exit. And here the judge said that time was of the essence in the agreement, and it was wrong to suggest that once the desired deadline had passed, there was no further urgency. He said that the clause should be read as including an implied term that if an exit wasn't achieved by the 31st of December 2019, then the parties should work in good faith to achieve it as soon as reasonably practicable and within a reasonable time after that date. So, having gone through those various different points in terms of construing that contractual exit obligation in the shareholders' agreement, the judge found that the company was indeed in breach of the shareholders' agreement and that this had been caused by the chair who'd been entrusted with the exclusive conduct of the sale process. So the chair basically pursued a strategy that was contrary to the company's obligations in the shareholders' agreement. So the judge went on to find that the company's actions had resulted then in the investor suffering unfair prejudice. So the date that I keep mentioning, the date by which the exit had to be achieved, 31st December 2019, turned out to be particularly significant because the chair gambled that the company would significantly increase its value if a sale was deferred for 12 months. But you may be ahead of me here because shortly after the deadline expired, you'll remember the COVID pandemic hit and the restrictions imposed on social and business activity in response to that pandemic meant effectively that the chair's gamble failed. According to the judge, if the company had performed its contractual obligation to consider all offers, then it would have had at least one or two conditional offers on the table by the end of 2019. And if it had properly instructed an investment bank, well, it might well have had more. So the judge agreed that the investor had suffered unfair prejudice, but he ordered another hearing to be held in order to establish whether or not the investor had actually suffered any loss as a result of that unfair prejudice. And that would turn on whether or not an offer for the company above $75 million, which was the level which the judge found was acceptable to the board, would have been received had the company complied with its obligations under the shareholders' agreement. So if an offer above that level had been received and the company hadn't pursued this strategy of delaying an exit, then the investor would have exited the business within the required time period and would have suffered a loss as a result. So we need to wait for that second hearing in order to find out what the result will actually be. I hope that's been interesting for you. A quick roundup of some cases, and I will see you next month. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.